Oh, you asked for that one?
Yes.
Oh, no, because I don't want to be accused of biasness. So I had to be sure that, okay.
Yeah, no, I asked for that.
No, thanks, Advocate Smith. We're going to process the questions through this format. We'll go through with you your questionnaire that we would have sent to you as we invited you to the interview. I'll take you through that. After that, the members of the panel, together with myself, will ask you questions. But in between, even through the questionnaire, there might be colleagues who follow up on issues that we have picked up. And then at the end, Prof. Fikeni will take you through the comments, public comments that we have received in that regard. Just going through your questionnaire, section 1, it's your personal details. I hope you've got the questionnaire with you.
Yes.
Okay, thank you. Section 1 is your personal details. We won't go into that. Safe to say you confirm that as your signature is there?
Yeah.
Okay. I don't think your mic is audible.
Is it better now?
Okay.
Thank you.
And then we move into the section that deals with your qualifications.
Yes.
If you can take us through your qualifications as part of the requirements for the post, how they are relevant and how they assist in the position of the NDPP.
Thank you, Minister. Good afternoon to you and good afternoon to the members of the panel. My name is Menzi Simelane. I'm an advocate I'm a lawyer and an advocate in practice. The qualifications that you see there are relevant in my respectful view because the position of National Director requires somebody who is a lawyer. So I'm a lawyer by training and I'm a lawyer in practice. As indicated there, I attended the University of Natal in 1990. I finished my high school in Harare in Zimbabwe. My family was exiled in 1984 to Lesotho. And from Lesotho, UNHCR moved us to Zimbabwe. So I spent my teenage years there. I attended Prince Edward Boys High School. I have a BProc and I have an LLB. And after completing the LLB, I came to Johannesburg and joined the Johannesburg Society of Advocates. I'd already been admitted as an advocate at the time. I was admitted in Pietermaritzburg in the High Court there. And then in 2000, I studied at the University of the Witwatersrand for a management advancement program. I did that just to assist me better understand and better appreciate issues of management because at the time, I was at the Competition Commission in various capacities. So I believe that the qualifications that I have are appropriate and qualify me for consideration for this position. Thank you, Minister.
Thank you. As we move into the next segment, which I think you have started to deal with, your work experience in terms of where you've been. Firstly, I hope I'll read at some, because it's a written document, so I'll use interchangeably your CV as it comes out.
Yes.
Quite better. Handwriting is like a doctor.
Sorry, cockroach ran through
process. Yeah. It says 1999 to 2005, you were Chief Legal Counsel in
Yes.
the Competition Commission. Then you moved to become, or then you became a commissioner as well.
Yes.
Competition Commissioner from 1999, 2000 to 2005.
Yes.
At that time, then you moved 2005 to 2009 to become the Director General of the Department of Justice and Constitutional Development. And then you moved 2010 to 2011 in the NPA as National Director of Public Prosecution.
Correct.
On your form, there is the NDPP 2009, which I couldn't find in your CV.
Yeah, that's correct. I may have missed it in the profile, but I first joined the NPA as a deputy for 1 month. I was, I think, a deputy for 1 month.
For 1 month?
For 1 month, yes.
Okay.
And then I,
Then I
acted, and then I became NDPP.
You acted for how long?
It was a very short while. I think it was also a month, if not less, and then I became NDPP.
Okay.
Yes.
And then after that, you became a special advisor to former minister who was at Human Settlements, or was
Yes.
in, yeah.
Yes, it was a Human Settlements, but I joined her when she was Minister of Public Service and Administration.
Or Public Service Administration,
Yes.
from 2014 till 2021.
About 2013.
2013.
2013, 2014, around
Okay.
about there. Thank you.
And then you've been an advocate. Currently, you are an advocate practicing.
Yes, ma'am. I'm an advocate in practice, yes.
Okay. That's fine. Maybe take us through how this experience is relevant in terms of your work. Looking at, so you've been at NP, and we'll come to the prosecutorial experience. You acted for you became DPP for a month in 2009, and then you acted almost again a month, and then you became National Director for Public Prosecution for a year.
No, ma'am, it was just about 2 years, if I recall, from about 2010, beginning of 2010, until about when the Constitutional Court judgment came out in 2012.
Or in 2012?
Yes.
Yeah, your CV says 2011. Okay, that's where the
just an error,
form
yeah.
says until 2010 until 2012.
2012,
Okay.
yes, ma'am.
Take us through your experience, how it would be, and we'll deal with the issue of the Constitutional Court later.
Yeah.
But let's now, for now, take us through how relevant is this experience that you have. And I'm also looking at the fact that you didn't stay long in the NPA itself.
Oh, yes. No, absolutely. Well, how do I put it? I think I was a bit fortunate because I joined the Johannesburg Bar in 97, beginning of 97, January to be exact. And at the beginning of 98, the Department of Trade and Industry, as it then was, invited young black lawyers through the PLA to make themselves available on what was going to be looked into, which was competition policy for South Africa. So I put my name down, and after a while I was selected as one of the people that was going to be, one of the 4 people that was tasked with revising competition policy in South Africa with a view to creating a completely new framework. So I did that. I then took leave of the bar. I went to do it full-time in that task team. We were led by Dr. Alistair Reiters, who was at the DTI at the time. That work we worked on policies, went all over the world doing benchmarking. We finished, we came back, the department was drafting legislation, we attended to it. It was taken to Parliament. We engaged stakeholders as well. It was a very, very contentious piece of legislation, Minister, because at the time, the government of the day was still discussing with business the best way to take the situation forward, in the sense that what had been discussed during the CODESA negotiations, amongst others, was whether the South African position going forward would look at abolishing, well, not abolishing, but dismantling monopolies, because the South African economy at the time was oligopolistic and monopolistic, There were certain specific companies, I'm sure many of you know them, like SAB. We had been making representations and making submissions about the appropriateness or not of that approach, which was seen at the time as maybe being too soon for consideration so early in democracy. So we did all of that, and the law was passed. And when it was passed, obviously the institutions are established, then lo and behold, they needed to be filled with staff. So there was a discussion about how do we start filling the institutions by incorporating members of the competition board, which was there at the time, into this space. We engaged with everybody that was involved, members of the competition board, the staff employed there. The conclusion was that the people that were responsible for putting the institutions may as well be the first people to staff them. And there was a discussion where I should go, whether I should go to the competition tribunal or the competition commission. We looked at it and it was felt that, well, I said, my view is that competition tribunal is making final decisions, and it sits, because it's a tribunal, it sits in an adjudicative fashion. I felt I was too young to be sitting to adjudicate matters at that point in time. I needed first to make sure I gain experience in the actual work itself. So it was decided that no, then I'll join the commission, and Dr. Reiters became the first commissioner. I joined then as the chief legal counsel. I think I was the second staff member. He was the first, and then we filled it up. And then the responsibility was to then staff it completely from day one. And we spent a lot of time discussing what kind of people we want there. The competition board, everybody in this room knows the history of South Africa. The competition board, for all practical purposes, couldn't create a culture of competition in an economy under the government of apartheid. It just wouldn't work. You know, there were sanctions, there were all sorts of things. So it was a protective economy that South Africa was in. And because it was a protective economy, the competition board really did not rigorously, at least it was felt, did not rigorously enforce the competition law at the time. So it was, for all intents and purposes, ineffective. So what was happening with the post-apartheid government is that in the new democratic government, the idea was to completely create a competitive economy under the circumstances that were there. So the idea then was, what kind of people do you bring into an institution that is completely new, that is in an environment where there's the new constitution, everything is practically new. You're getting a blank sheet of paper and you're being tasked to do as you please in order to make sure that you get the best that you can get, in order to make sure that the objectives of government are met. So we made a lot of decisions. One of the first things we did was to make a call that we don't want anybody over the age of 35. We were not going to recruit anyone over the age of 35 because we felt that it needed to start with the young crop of South Africans. Even if they're fresh out of varsity, we would train them from beginning. We needed fresh thinking, new ideas in line with what government intended, in line with the constitution, people who were hopeful about their future, people who would go in there and work and not have everybody or somebody remind them how it was 5, 8, 9, 10 years earlier. Because we found that with officials of government that had been there for a while, the tendency whenever things were discussed, they would want to remind everybody of how things have always been done. Then it's difficult to effect the kind of change you want to effect in that kind of environment. So we felt that it's a perfect opportunity, new people, new training, new approach. So we started there that way, and we started training people accordingly. We did incorporate a few staff members from the competition board, so it didn't become a problem because it was a very small institution. I think no more than 15 staff members at the time. So the advantage of that, which I'm happy to observe to this day, is that the systems that we set in there, the institutions practically run themselves, the institutions function, the institutions have legitimacy, they're accepted in society, and they're first world institutions. In fact, I can't remember the year, Minister. In fact, there was a time when the big problem with South African, well, not the big problem, one of the advantages we did is that in merger transactions, we were the only country in the world, we introduced it was 4 requirements that had to be considered in major transactions. We introduced what we called public interest grounds. Public interest grounds related to employment and any other issue of public interest that wasn't strictly economics. Antitrust law, competition law is about economic efficiency. And it's strictly, measure economic efficiency. Once there's efficiency determined that the measure is good to go, you should approve it. That's what is called the Chicago School type, very conservative kind of approach to industrial economics. But because of our unique situation, we introduced public interest grounds. And the many jurisdictions that we compare ourselves to in the West frowned on this, and they spent a lot of time persuading us to not go that route. And we stood our ground that, you've got to understand our situation, and it was accepted. So the public interest grounds continue to be used today. There's question about whether they're now relevant after COVID basically changed the international economic environment. Some argue that it's difficult to sustain because business needs to rebuild, but others say because of huge job losses as a result of COVID, there's still some merit in maintaining that. So I'm proud that the institutions remain effective as they are. Nobody, very few people, at least that I knew, were experts in competition law when we started. Right now, there's a whole lot of experts. And I'm quite proud to have been part of a crop that ensured that competition policy in the country, specifically for historically disadvantaged practitioners, is something they could start with at the beginning and grow into, as opposed to the traditional approach where historically disadvantaged graduates, law graduates, go to specific law firms with a view to acquiring experience or practice in the area of the economy. That's usually was the approach. In this case, they actually we started with them by employing quite a number of them. And most of them now actually are partners and directors in many of the law firms. So the graduation was quite seamless. What I'm also proud of is that unlike many areas of the law, it's one of the most de-racialized area of practice in South Africa, in that a lot of young white lawyers also got a lot of interest in competition law. And some did come and join, because we did recruit quite a number of white staff members. Others who engaged with the commission got interested in it, and they found ways of engaging with it. So the long and short of it is that competition law is one of the rarest de-racialized areas of practice in law in South Africa, and I'm proud to have been part of that particular setup. Then, well, obviously I was chief legal counsel. Then I became commissioner. Dr. Richards was only commissioner for 6 months. Then he was appointed director general, and I was interviewed for and succeeded in replacing him. I then became commissioner. One of the things then that we had to do, just to get back to the point I wanted to make, is that I think it was about 3 years later, the OECD put South Africa on the list of countries that were to undergo a peer review. So we had to prepare for the peer review and go to the OECD to be peer reviewed. So I led that team with other staff members, and Mr. Dave Lewis, as he then was chair of the tribunal at the time. We sat like this at the OECD, went and sat at the front, and all the other countries were there. And they practically peer-reviewed us to check if we were a jurisdiction that practices antitrust law, as it is called, or competition law, as some call it, in the manner that meets the standard of the OECD. And we did very well there, and I think if I recall, that first assessment put us in the top 25 in the world of the countries that practice that law. Then from there, I was invited to make myself available for the position of Director General at Department of Justice. On the 1st of June, I joined the Department of Justice as Director General, 2005. Well, you've got to look at, for context, that administration. If I recall, it was the second, if not third administration. There were a lot of things of a policy nature that were taking place in the country across the board, from dealing with access to ARVs, all those conversations, dealing with the medicines. I started dealing with them while we were at the Competition Commission. There were issues about smoking, banning smoking, that was coming from the Department of Health. Also, the Competition Commission was pushing very hard on breaking barriers. So that period was quite robust, if I can use the term. In the area of law, it was probably one of the most difficult and most robust areas, because we're talking transformation of the judiciary. It was even before the Constitutional Court got set up. It was still, I think, setting up very slowly. The primary focus was still Bloemfontein in the SCA. So as DG, I was part of the processes that had to create the apex courts in the Constitution. Transformation of the legal profession, we did a lot of that. For my sins, I pushed a lot of things that I think are following me to this day, and I'll deal with them briefly. How did we do it? Through pieces of legislation. The Legal Practice Act was something we started at the time. We conceptualized it and we said, when you look at the legal profession, obviously through the input of many stakeholders, we needed a legal regulator in South Africa, or a regulator for legal professionals that would be controlling overall, as it were. Remember, just like the DPPs in the NPA from different provinces, we had law societies in South Africa, so there was an argument that there must be one. So we put in the legislation that there must be, or in the policy discussions, that there must be a legal practice act that would deal with all practitioners and the Legal Practice Council. And some of the biggest fights there were about what the legal practice form in South Africa should be going forward. For my sins, I was one of the people that pushed for the abolishment of bars. I argued that South Africa doesn't need the various bars as we know them. We must fuse the system. I was a believer in the American approach to legal practice, that we should not rope, we should not have these ritualistic, traditional things that you see in the legal profession. You go to a courtroom, you robe, you dress the way you dress, it's cold, it's dark, and it just didn't lend itself to making people feel that there was justice. Everybody walks into a courtroom, the first thing they do is freeze, because it's just so cool and dark, it's hard wood, and all of those types of things. So I was part of the group that believed that we need a different approach, and I pushed for that. And it didn't sit well with a lot of people. There was a compromise. We instructed that the compromise is, let's keep the tradition as is, but let's push for or put in place hybrid practices to say if people couldn't become advocates, but they wanted to be advocates, for some reason they couldn't pass the exams and do all of the kind of things, where would they want to practice? So hybrid practices, that's how they came in, to say lawyers can be employed anywhere, in accounting firms, in law firms, provided there were firewalls in place to separate, because the advocates profession must be independent. So I lost that debate, accepted it, and that's how we moved. That's why you have the Legal Practice Council today through the Legal Practice Act. We also conceptualized the Solicitor General position to say, let's have, in the same way that we're having an NDPP, who would attend to civil matters on behalf of government. So again, I looked at the US approach, I kind of liked it, and we promoted it in the department, and it was felt that let's have it. By the time I left the department, the framework hadn't been, the legislation hadn't yet been passed, but it was accepted that we'll have a Solicitor General, amongst other things. Then we rationalized the courts in the Superior Courts Act. We worked on the Superior Court case with Advocate Johnny Delange was a deputy minister at the time. So we looked at all the courts in South Africa, district courts, regional courts, and the high courts. There are different areas of jurisdiction, the magisterial district, to reconfigure them, to try and make them match what government believed at the time was what was needed. It was interesting to me that, in fact, regional courts were established in 1977. And it was interesting that they were actually established to respond to June 76 happenings. So when you learn that kind of history, you get to see the logic of what the government at the time was trying to do. And you try and look at it and say, is this what you need going forward? Or can you take what you are inheriting and work with it to where we are today. So the approach was we work with what you find. In any event, that was part of the 1994, the CODESA settlements, that the legal system is accepted as it was, structured as it was. We follow the common law and the Roman Dutch law, and then we have the constitution, which will support them. So it wasn't really a problem. So that's how...
So that regionalization happened.
Rationalization did happen in the sense that we rejigged magisterial districts. Again, because there were new provinces. I think there were 4 provinces initially, so they were expanding. All of a sudden, there were 9. So we had to look at how, for example, in Pretoria, there were issues about former BOP, which was now part of Pretoria. And so we had to redo the whole jig. I don't remember it 100% now, but it was all redone. Overall, the 300 courts that we ended up with in the country encapsulated that type of rejigging. With that came with jurisdictions, civil jurisdiction, what jurisdiction to give. Over time, it grew to the point where I think, family courts and family law also got dealt with from the black divorce courts, CDC, to the magistrates courts. So we did all of that, increased the jurisdiction, gave the regional courts more, primary jurisdiction for some serious offenses in the same way as the high courts. So that's why you find that you can be prosecuted for murder in the regional court and equally in the high court. And sometimes people don't get to understand. It's just a split of jurisdiction to accommodate the volumes that are there so that matters are dealt with as speedily as possible, at least it is hoped. The majority of criminal cases, close to 60, 70, if not 80%, take place in the lower courts. So those are the primary, really important courts, despite the thinking still remaining that the high court. The reality is that it's actually the magistrates' courts that matter more, in my respectful view, than the high courts. So I got involved in all of that. There's so much. Dealing with judges was probably one of the biggest issues and transformation, because the legal profession is generally conservative, extremely conservative. And there was a general view at the time that the Constitutional Court judges were political judges because of who they were, irrespective of their stature. Those were the undertones that were confronted with in engaging, that no, the Constitutional Court judges, those are not real judges. If you want to be a real judge, you go via the SCA. So in this debate around the apex courts, one of the views was that leave them as they are. A strong view, which I would say was associated with pro-transformation advocates, it was that remove the SCA, we don't need it. Take it and make it part of the constitutional courts, holus polis, but win out those who would be resigning or retiring until you have the acceptable number. There was a big debate on that. After a while, the conclusion was that, no, let's leave it. Let it be an intermediate court. Let's cut out the fight. Let it be an intermediate court. The constitutional court would deal with matters from there. So it was interesting dealing with different types of personalities, different judges, others very strong-willed, others okay, others, like everybody else, can be not so pleasant. But one, by virtue of the position, I had to deal with that and assist the executive as best as I could. And the stakeholders, naturally, it was a good thing working with them, with all those different views. So that mix of pushing that transformation agenda was quite interesting, and dealing with the prejudices that were there at the time. Then the next level was about the appointments of judges. So again, a big debate about appointment of judges. It was quite a serious thing because most black practitioners and most black judges felt that the crop that was there didn't welcome them and didn't want them there on the basis that it felt they are not yet competent, they are not that ready. So there was this traditional view that you go through the ropes, you take time, you must be, sort of supported by certain people before you moved on. So the transformation advocates weren't as patient as some of the suggestions seemed to be, and there was a big push. So there was a lot of difficulty and a lot of fracture in those relationships. And again, I was in the middle of that because as DG, we had to make sure you provide resources to all of them. You had to engage with them and accommodate them. It covered all nitty-gritties, really, including the cars they get, which, Minister, you'll be aware, judges take very seriously what they considered were their perks. We rarely even thought about perks because many judges felt, I already have these, I'm already used to it, it's a perk. If you take it away, you're taking away what I'm entitled to, there's going to be a problem. So you're just like, you know what, you have it. It's your right, you're entitled to it if that's what you want. So a lot of movement back and forth was the issue. Then there was a push for arbitration. Others in the private practice said, well, we want arbitration, courts delay and all of that. And black judges felt offended by that suggestion, that now that it's us coming in, we are pushing for arbitration, which takes matters out of court. So we had to get in the middle and start debating that to say, really, is it taking matters out of court because the new crop coming in is being undermined, or is it really just an issue of volumes? We decided that it's not necessary to resolve it either way. The fact of the matter is that there's huge volumes. Arbitrations are not a bad thing. They're an international thing anyway. Let's find a way to deal with this. And the judges that you accept. We have that particular framework now.
So the involvement here from the department point of view, was it from a policy point of view or the judiciary had allowed, as the constitution will call for the independence of the judiciary?
It hadn't got to that stage, Minister. The department was still hardly involved. They wouldn't move without the department. They couldn't move without the department. That was the inherited culture that we found, that the Department of Justice was central to everything the lower court judiciary and high court judiciary did. So they'd pick a call and say, DG, we need you here, and I'll quickly drive up or go meet. We arrange those types of meetings. The issue of independence started coming in a bit later to say, look, how do we ensure that there's independence? Because even that was a big fight, and it's still going to remain a big fight because there are no, well, I think it's getting settled a bit better now, maybe to be better going forward, but there are still views about how much independence. On the side of the executive, the concern was always judges can't handle money. They're just like public servants. They can't handle money. You give them money to handle. To what extent are you making them vulnerable in the sense that when it's time to account, would they go to Parliament and account? It's not going to happen that way. So let's, as the side of the executive and the department, be a little bit firm in not moving very fast in that direction. But the engagements continued around independence. I think it went well because I think it was accepted. Many judges, that I engage with, many of whom are my friends, would say that we like this arrangement because we want these benefits, and if there's something to account, you'll take care of if anything happened. In fact, with cars, many times one would go and find that there's a judge in a spot of bother because somebody who shouldn't be driving a car was driving it and it had crashed. So somebody had to clean that mess up, and we took care of that business, and amongst other businesses we took care of. So we protected the judiciary a lot as part of this transition for good reason, and I think it's a good thing to do. But we're right at the center of it. And over time, Minister, as you would know now, the decentralization has gone to the point where it's at now, where it's a department and so forth and so forth. So it's a bit different. But the issues is that then as DG, one dealt a lot with clerks of the court and registrars and deputy registrars who perform quasi-judicial functions. And it's an issue that will be looked at going forward, and it must be looked at because those judges make orders, but when you get the document, some of them the registrar is signed, which is an official in the public service. So in other words, what is a registrar? Where is a registrar located? The registrar or a clerk of the court in the magistrate's court is located in the executive, but they're signing documents of a legally binding nature that belong in the judiciary. What does all of that mean? So it's an inherited culture, but it's still there, and slowly has to be looked at to see the impact of that. So I dealt with that on that side. We dealt with the master's office. I know a lot of people look at the master's office as a place where you go get a stamp and get a letter of executorship. But my respectful view is that the master's office is an economic department in a way. It's an economic unit because what is logged in there is economic value. the reason why people want to go get those letters quickly out is because they want to access money so that they can spend. So we dealt with that as well. And one dealt with the state attorney's offices, manage those and all the troubles that are there. I can talk for days about the issues that are there. But by and large, Minister, that experience as a DG, I covered a wide range of topics. I won't remember all of them now. But I also I co-chaired the JCPS cluster. If you're a DG of Justice and the Department of Justice co-chairs the cluster with another department, at that time it was the police. So I co-chaired the JCPS.
Still the same even
Still
now.
the same. Some things don't change. Well, I'm sure it's better now. But I co-chaired, so my co-chair was National Commissioner Jackie Selebi at the time, and we dealt with all the issues that the cluster entailed. And I also sat in the National Security Council of DGs that dealt with those kinds of matters, and we reported accordingly. Post-TRC matters, when the report was accepted, Cabinet sent it to the Department of Justice to manage. So I was tasked with the responsibility of creating the infrastructure for those matters to be dealt with. So we established the TRC unit, and the executive authority at the time looked for an appropriate level person to head it in light of the sensitivity of the issues. And the late Ambassador, Dr. Sekwe, were able to have his resources available, and he headed the TRC unit. And then we capacitated it with the relevant staff, and they ran with the reparation side of the business. The prosecution side of the business naturally went to the NPA, and it was dealt with in the PCLU. And talk about the NPA as DG, I was responsible for, at the time, everything, until 2008 at least, or roundabout. I know the PFMA is a 2008 legislation. I can't remember when exactly it came into effect, but before the PFMA, the Director General of Justice was responsible for both the public service side of the department, as naturally we are head of department. You are responsible for all the programs. And also the financial side, in that you follow the Exchequer Act in order to deal with finances. When the PFMA came, it made things clearer that the head of department is the accounting officer for the department in respect of finances, and you run pretty much the whole shebang. What that meant, obviously, for the NPA is that I was responsible as well for the NPA in respect of everything, except decisions to prosecute or not to prosecute. But in respect of everything else, the Director General was responsible. I had to make sure that the NPA got everything that it needed. And in order for the DG to account, I had to get all the reports from the NPA that were necessary in order to account in respect of finance matters and in order to account in respect of public service matters. The one exception at the time was the Directorate of Special Operations, because it had its own legislation. It had its own legislation, and in terms of its own legislation, it was for all intents and purposes independent. So I had nothing, as a DG, I had nothing to do with the DSO. But for everything else in the NPA, especially what would be a corporate services side of it, I was responsible for. Then also I was responsible for reporting purposes and overseeing some of the entities that the department was responsible for, primarily legal aid. It was Legal Aid Board at the time. It's now Legal Aid South Africa. So with Justice Mlambo, who was chair for 10 years, we worked very well together with Vidu Vedulanka, who was the CEO, to change the way legal aid was perceived by the public, and also how legal aid itself, official staff perceived themselves, and so forth and so forth. Because it had a board, it had people, I was a few steps away from it, but we provided all the necessary support that needed to be provided there. Then, come November 2009, after which I'm sure we'll discuss, you're looking forward to it, the removal by National Assembly of the National Director of Public Prosecutions at the time, I was then was appointed as deputy, and I went there, and I subsequently got appointed as.
You were appointed after his removal?
Yes.
Okay, as deputy.
Yes, he was removed. Then they were acting there. Advocate Mshe acted, if I recall, for a while.
Okay.
And I remained as DG Overseer at the time. Advocate Mshe acted, and I think I then got appointed as deputy. I worked under Advocate Mshe, and then I was appointed National Director.
Okay.
So that's how it worked.
Oh, you moved from the department to
the NPA.
To the NPA.
Directly, yes. That's how that worked. So, well, just in terms of the staff that one managed, the Competition Commission didn't have a lot of staff, not more than 300.
Now get to the NPA as your work before we come to management.
Oh, okay.
We want to hear your tenure at
tenure at the NPA.
Yeah.
I had an advantage, I believe, because when I went to the NPA, I already knew about it while I was DG Justice. I pretty much knew everything that was going on there, the good things.
Because you were the accounting officer.
Because I was the accounting officer.
Okay.
I knew the good things, I knew the bad things about it. So all the controversies around the NPA at the time, I already knew. I had the information. Also because I was chair of the cluster. So in the cluster, we would discuss all these things. So I already knew. The troubles that were there with the DSO, I already knew. In fact, when I was DG, one of the responsibilities post the cabinet decision was that the DSO must be disbanded. And I was tasked as DG naturally with the necessary putting in place of the legislation to disband, and the department prepared the legislation, and it went to the National Assembly. It was passed, and the DSO was disestablished on that basis. That was my job as DG to do, to follow instructions as they were given. So I was already...
During that time, were you involved in staff, because there was DSO staff, movement of staff? To what extent were you involved?
Yes, yes, I was again very involved in that, because I think this establishment was around 2009. So when I moved to the NPA, it was still in that sort of transition process in Parliament. When Parliament passed the law, I think I was, at the time, I was acting NDPP. I was acting NDPP. So as soon as when I landed there, it fell in perfectly, because I remember one of the first things I did was, when I became NDPP, they came to pick me up in these jeeps that they had, some black jeeps, very popular jeeps that the Scorpion used to run around and chase after people. Jeeps, I think they're very special jeeps. They're called Jeeps Cherokee SRT, stands for Street Racing Technology. So if you stop off the range, I refused to get in there. I said, I'm not getting in this car, because I no longer have the authority to utilize it, because it belongs to the DSO. And in terms of the dissolution arrangement, the NPA no longer has investigative capacity. So I can't touch anything to do with investigation, because the NPA no longer has that. So the question was, okay, so what do we do now? Because this is the situation. A lot of files are here where they're stored in the NPA. There at VGM building, there's a place where they store stuff. Based on the stories I used to hear, I was afraid to go there. I never went there. But stuff was stored there. So I simply said, you know what? With all these cases that you guys were investigating, I think Dramat must handle them. So I went to see
Dramat was heading?
DPCI.
DPCI.
Because when the DSO was disestablished, the police then had to establish the DPCI. But because the Department of Justice was at the core of disestablishment of the DSO, I was intricately involved in that, in the design of the DPCI. They drafted the legislation, but with almost like regular joint teams to discuss what the DPCI should look like, because there were different advocates for different models. We favored a model where the DPCI head would be at the level of National Commissioner and would report directly to the Minister of Police. There were debates in the police, there was a pushback, and the argument that won the day was that, look, you can't do that because the Constitution makes provision for a single police service. If it's a single police service, there must be one head, so you can't create two. We fought about it, but we looked at it, we're like, okay, no, it's fine. It seems to make constitutional sense. So that's how the head of the DPCI becomes a DDG level. person. So we removed in the structure, in the design, the head of the DPCI reporting directly to the minister, and we put him under or her under the National Commissioner. But their function, we designed it in such a way that we tried as much as possible to retain the architecture of the DSO, to say they shouldn't be really the same, because the intention originally behind the DSO was always to have a specialist kind of unit, as many would know, a la FBI or Scotland Yard and that type of thing. But it just didn't happen that way for a variety of reasons. So that's how we end up with the DPCI structured the way it is structured. So when I got to the NPA, it then had to inherit when Dramat was, General Dramat was appointed. So I just drove quickly because they were next door to him and said, no, Chief, I didn't say Chief really, but I said, we have this situation. I've got all these files, I've got all these things that I need to handle. I don't have legal authority over these things. I'm dumping them with you, starting with these vehicles. So I just asked the guys, drop these vehicles here. So we left them there. So he accepted, he knew the situation. He said, okay, no, I'll deal with this thing. In the NPA, Willie Hofmeyer was one of the deputies.
But was that a proper handover process?
No, there was a handover process that was
because
proper.
the way you are sounding, advocates,
No, okay, I
you
understand.
just went to Dramat and dumped the cars and say the files are there. It sounds scary.
No, there was a proper process. No, I went to him. We arranged that the first order of business is that the vehicles we don't need. So, and he said, no, let them be dropped here, let them be parked here. We'll attend to them. So, in an orderly fashion, the officials of the NPA went and parked the vehicles over there. With respect to the files, we agreed that the DPCI must take over the files and that a designated person would be responsible for that. So in the NPA, I asked Mr. Hofmeyer, Willie Hofmeyer, to attend to that process. Why? Because it was natural. He had been there, he was head of the AFU, he knew all the guys that were in the DSO, as many as possible, they were comfortable with him. And I just thought, coming from the department, having dissolved and dealt with all manner of things relating to the DSO, it's best if I step back from the process. And I said, Willie, please take care of this situation.
Willie Hofmeyer was one of the...
He was one of the deputies. He was my deputy at the time.
Okay.
So I said, please take care of this thing, all the files, you know everything, whatever needs to be done, it needs to comply with the law and therefore move over. With that, there were fights. Guys in the DSO, now where do we go? The point was, you choose. You decide where you want to go. You can go to the SIU if you want. You can go back to the police if you want. The conflict, not the conflict, some of the difficulties some of them were beginning to experience is that they were in the police first. That's how some of them ended up in the DSO. When they left the police to join the DSO, they were a junior in the police. In the DSO, they got promoted. Now, when they had to go back to the police, they had to go back at an equivalent rank. And they were immediately senior to most of their former colleagues by up to 2-3 ranks. And the police would have none of it. They were like, there's no way you're going to leave my junior and you're coming here, you are now my senior and all of that. Anyway, it eventually got managed to say, look, there's nothing anybody can do, it must be done. Fortunately for me as NDPP, not my monkeys, not my circus. The police dealt with that matter on their own. The issue for me became those who wanted to go to the SIU, to say, look, we want to go to the SIU. And there were issues. Why you want to go to the SIU? Well, we're comfortable with this framework. So Willie Hofmeyer came to me and said, NDPP, what do we do in this situation? I said, let everybody make a choice and go wherever they want to go. Nobody must feel they've got nowhere to go. So because others were having difficulties in the police, the majority of the DSO guys went, well, not say the majority, almost 50-50 really. Others went to the police, others went back to the SIU. So that tradition carried through in the SIU. At the time, Willie Hofmeyer was in 2 positions. He was Deputy National Director responsible for the FU, and he was the acting head of the SIU. So he attended to that, and then they also attended to the transfer of files. But what they tried to do, which I got resentful about, was they initially didn't want to transfer the files. They said to me, NDPP, please sign these prosecutions. And I said, what prosecutions? One of them was, I think it was Busasa. They said, no, we've been investigating Busasa, can you sign off on this? So I refused.
Busasa
Yes, Busasa.
company.
Yeah, Busasa. I don't know what, I can't remember what it was before the name change.
Okay.
But there was something to do with it. So I said, no, I'm not signing anything. Why? We're ready, please sign this thing. I said, no. Why? Because firstly, serious suspicion. You know, I knew the kind of things that the TSO was accused of doing from many quarters, in the sense that as DG, the executive authority received a lot of letters of complaints. I got sight of some of them, others I didn't, but there was a general complaint about the TSO. The nature of the process of removing the NDPP at the time was also quite a contentious and very unpleasant process for everybody, for a variety of reasons. Within the cluster, the issues that we discussed there of a national security nature, to the extent that we could discuss them over there, others would discuss them in a closed forum under the National Security Council of DGs. Really unpleasant things. So when somebody or some people come and say, please sign off on this prosecution, I was like, I'm not signing. These were memos and so forth. So I simply said...
Let me just ask something
Yeah.
and clarify. When you say that you wouldn't sign on the basis of what was being said, wouldn't the responsibility be to sign on the basis of the docket and the merit of the case? Would you have looked at the case itself rather than what everybody's saying, the JCPS? Because, I mean, if you come to us even today, if anyone asks me about a case, I'll have a view. But I don't know the content of the docket.
Yeah.
Now, the NDPP would have to make a base decision on the basis of information inside the file.
Yes.
Now, I get worried the way you are classifying your reasons for this.
No, that's correct. No, that's correctly that. Because when I then asked question, well, it was the manner in which it was being done as well, in the sense that, you know, there's no formal meetings being set to say, look, let's meet and discuss and look at all these types of things. It's talk as we attend to other things. You need to sign off on this, or sign off on this. So I simply said, I'll gladly sign. One problem. These matters are not ready for prosecution. You guys are still investigating. Yes, we are still investigating. So I said, well, on that basis, I can't sign anything that is not going to start a prosecution. These are matters that are still under investigation. You're not finished. I don't know how far you are from being finished. So I don't have authority over investigations because the NPA no longer has investigative capacity. So please take these to Mr. Dramat. Well, I didn't have them with me. They didn't give them to me. They just mentioned them by name. I said, please take all of those files, take them to Mr. Dramat with all the trunk, I don't know, can't remember what those things are. That's where this stuff, documents, things where I said, no, take them all to Dramat. They'll attend to them as a DPCI.
Maybe let me re-ask the question. So are you saying at that time where these files were brought to you, you had this inclination or you believed that these colleagues were disingenuous, were not genuine, were acting rationally?
Correct.
By bringing this because they had not done, and they were rushing to bring it to you so that the files don't go to the other side?
Correct.
Which shouldn't have been, and that's the basis.
Correct.
Is that what you are saying to
Correct.
us?
Yes, I was very suspicious of that.
So they were
particular process.
dishonest in their conduct? Because if they've done that, that's dishonesty.
Well, I'm going to be very careful about my wording because last time some suggestion of that nature was made, I said, yes, I got into big trouble.
Oh,
Let me put
okay.
it this way. We'll deal with it, Minister. The issue was, can I go a step back? Let me go a step back. What was the problem with the TSO? The problem was simply this. The legislation of the TSO gave the TSO intelligence capacity. So they had a mandate to gather intelligence. The problem operationally is that there were then multiple agencies in the country that gathered intelligence. And on the ground, they couldn't work very well together. There were various suspicions for a number of reasons, mostly historical, pre-1994. People on this side knew people on this side. They didn't trust each other. So all those legacy issues found expression in the actual work of these institutions. And because of that, you know, it was so bad and so difficult that in one incident at the airport, we got a report as the cluster that the DSO and the police agents who were undercover following some suspects almost shot at each other because they didn't recognize each other, that they're after the same target. And the question was, but aren't you talking? Why are you after the same people and not know about it? No, it's because these guys work with this way, these guys work this way. So it became ugly. It got to the point where the president at the time appointed the Gampepe Judicial Commission of Inquiry to look into the manner in which the DSO was dealing with intelligence issues, because it had reached a point where arguments were made that there is a national security problem because of these kinds of issues. Those who were closest to those issues, I didn't. Those who were closer to those issues, it was NIA at the time, together with the Secret Service. There were still two at the time before they were amalgamated and they've now been separated. Those two DGs there raised these issues with the crime intelligence and the police. Also, DI got involved in it. But that whole mechanism of trying to explain to the executive what kind of problems were there with these kinds of duplications led to that point. So again, as the Department of Justice, we took responsibility for supporting the Commission of Inquiry. My officials provided that. The minister was responsible, obviously, to make sure that the commission functions properly, attended to her responsibilities accordingly. And evidence was led and all sorts of things, and the Gampepe Commission reports came with an acknowledgement that indeed there is an unsatisfactory manner in which intelligence information was being handled by the DSO. And primarily, some of the allegations were that they were infiltrated by foreign intelligence, and they were continuing to work in an unauthorized fashion, or at least in a way that it wasn't through protocols as intelligence environment would require. They were doing these things on their own. Their argument was, read our law, we have a mandate, we could work, amongst other arguments. The long and short of it is that by the time I went to the NPA, I was aware of all of these things, and the fact that some of the people complained about were in the NPA and how they were managing things. So by the time Vili and some of his staff made these suggestions, so they didn't bring the files like this, Minister. We're just talking to say NDPP, there are files, they're over there, you can see them if you want to see them. They need to be signed off on for prosecution. So for me, I was like, no, red flag, based on what I knew. But the cleanest way of dealing with it, and to say, is that, you know what, they're just not ready for prosecution anyway. So let them go to, and that's how they moved over to the other side.
I think Mr. Mtlung has got a follow-up on this matter.
Thank you, Minister. Advocate Semelani, I just, on riding on the question by the Minister.
Yeah.
And it appears that you relied on a verbal report in terms of a request to sign off. Wouldn't it have been prudent of you to seek or to request the docket or any documentation just to satisfy yourself? I understand the issues around mistrust
yeah,
and so on and so forth. But as the head, wouldn't you have perhaps insisted on satisfying yourself, particularly taking into account that you considered the process, or rather the investigations to still be ongoing? The investigation was still ongoing at the time, yeah, according to the report, the verbal report.
Yeah.
But you did not satisfy yourself.
Yeah.
Was it not prudent of you to actually go further and obtain all the necessary information to satisfy yourself that the decision that you were making was the correct decision?
It was the correct decision. It became unnecessary to even go that route, for the simple reason that, to the extent that matters were still under investigation, the NDPP has no investigative authority by law. The NPA has no investigative authority by law. There's nothing further for the NPA to investigate in a docket in the manner that those matters still needed to be attended to. So those matters were matters that were supposed to be handed over in a formal handover to the DPCI for further investigation. It didn't even become necessary to even go that route. In fact, it would have been improper to even go that route. Because what authority would I have been exercising in law? These are open dockets under investigation. What would they be doing with the NDPP? What law would you be using to look into them? So these were just unfinished matters. They needed to go. That's why for me, even the suggestion that I look into them was annoying. Like, no, I can't. I mean, what do you think I am? So that's how we did it. So that became unnecessary. So I asked Mr. Hofmeyer to just attend to the necessary and do the handover. I delegated the process to him. So he attended to that in the normal course.
Was it the head of DSO who said you must look at the file, or was this investigators?
No, it was Mr. Hofmeyer.
It was Mr. Hofmeyer.
Yeah, he was handling the process for me.
So he was handling that, and then he says, no, I've got this file.
Yes.
I need you to sign.
Not this file. We've got these unfinished matters.
Okay.
Yes, they were in boxes or in trunks stored somewhere. They didn't bring them to me, but he wanted to say some of them need to be looked at and you may need to sign some of them. So when I asked, okay, what would need to be signed, what's happening, what's the progress, these are matters that are under investigation. And
so not like prison, so all of you didn't go file by file?
No.
Because ordinarily you'd have to go through the file and say, this is file so-and-so, like Bosasa. How did you know the Bosasa one?
They mentioned it.
They mentioned,
Yeah, they mentioned
to say one of them is this.
Yes, they mentioned
and
it.
then amongst others.
Yes, they mentioned
and
it.
And that one, they were saying they are ready to go, please sign.
Yes.
And you said, no, I can't sign.
Yes, because the patent, when you ask a few questions, they say, no, we're still investigating, we still have to do that. Like,
okay.
Why are you asking?
So it was on the conversation that you started to say, okay, you want me to go and get those files. Therefore, but are you done with your work? And then they say, no, we're not done.
No, we're not done, yes.
We were still investigating.
Yes, precisely.
Okay.
Then I said, no, then if that's where you still are, then we shouldn't even be having the conversation.
Okay.
So in essence, then, Minister, that experience, I take it that the part about the removal of the NDPP, the general inquiry, I want to deal with later, because that was when I was DG. I know it came up in the objections. I don't know if you want me to deal with it now. Or, okay, no, that's fine. Segment. No, that's fine. Okay.
Sorry, my apologies. We're looking at your tenure now.
Yes.
As the NDPP,
yes.
Compared to all the other candidates, you're the only one who has been even at that. So others will look at them from where they've been in the NPA and their role. So we wanting you to tell us, why must you come back? You've been the NDPP, what is it that you have done? So your career at that time, your tenure at that time.
All right. When I got there, as I said, I already had a pretty decent idea about what's going on in there. One thing that which one am I going to start? You get there are deputies, and then you have one deputy in charge of NPS, National Prosecution Service, one in charge of AFU, one in charge of this. So
you had three deputies. The law allows for 4 maximum.
Yeah, I think I had 3 at the time. I don't remember 100%, Minister, but it was AFU, it was
AFU,
NPS,
NPS.
It was Dr. Ramaite was there. I can't remember what you were responsible for. Yeah, there may have been 3 at the time.
You found them there.
I
you
found
were
them
one, and then you got appointed.
Yes, then I got appointed, yes.
And then you replaced yourself. Did you eventually get
yes,
replaced?
If you want to put it that way, yes.
In the 2 years?
Yes, that was the order of things. So when the issue was like, okay, more senior staff, so I need to have a meeting. So I was told, no, you're going to meet here, the deputies, and that's the exco of the NPA. So we had our first meeting, but I looked at it as like, okay, so where are the DPPs? They said, no, DPPs are not part of exco. They answer to the deputy in charge of the NPS, and you get your briefings via the deputy head of the NPS. So I looked at that with a squint, and I said, I don't quite understand this, because I didn't understand the law to be this way. I said, if you look at the Act, my understanding is that the DPPs are the ones in charge of their areas of jurisdiction. That's what I know. So, and they are the ones who institute proceedings to prosecute or not. The NDPP has the power, but hardly does. It's very rare, but the law authorizes the the DPP. So why would they not be here? They said, no, the NPS head does it. And I said, no, to me, this feels a bit uncomfortable in the sense that structurally it just doesn't feel right, that people who are responsible, with primary responsible for taking initial decisions, and that as the NDPP I have authority over, I should hear from them via a third party. So I said, look, it's fine, I don't have a big problem, but I'd like to change the arrangement. From now on, the exco of the NPA would be the NDPP, supported by the deputies, and all the DPPs. They must come to exco and explain how they function in their areas of jurisdiction. Deputies didn't have a fundamental problem with it. There's a bit of uncomfortableness in it. I said, you know, we'll all see the benefits of it. So the first exco with the DPPs present went very well, and everybody was happy. The principle was, you are in charge of a jurisdiction. It's a, what we called it was, it's a federation kind of environment. You do by law what you're empowered to do. That's your business. I'm not too interested in it. But you come here and you account for whatever you have done or not done. So I expect you to brief me directly. Then I realized that there were no performance agreements, because the question was, okay, how do these people report? So I insisted right then. I asked one of the SPPs who was assisting me to say, please take the performance agreements of my former DDGs in the department, have a look at them, and create for me a performance agreement that I can have with the deputies and the DPPs, because I need to find a way of managing it. So that's how I introduce performance agreements at that level in that environment. Then I tended to other things. I think I've got here some of the stuff that I did. What I then found as well was that there were a lot of legal issues that came to the NDPP. And I asked around to say, who handled these things, process them before I see them? Because they were coming directly from various offices and the PA and the type of thing. And it became a bit unclear. So I established what is called LAD, which is the Legal Affairs Division. I said, no, but I need some lawyers. Let me get a few guys from within who are legally qualified. Can I form a small unit to be Legal Affairs Division? And I got me Advocate Gerard Nel, who was there at the time, to basically, was the most senior, was an elderly gentleman, to go on retirement. I said, because he's an elder, can he just supervise these youngsters and be in charge of LAD? Basically, their job was to get all material that is distinct for the NDPP, have a look at it, and advise from time to time on legal issues. So I established that unit. It exists. I think now it's headed by Special Director, Mr. Advocate Marga. Then, as part of the discussions, one would then get informed, obviously, of a number of complaints about typical labor relations complaints and complaints about officials. And I got to learn that there was a unit called the Integrity Management Unit that was tasked with investigating NPA staff generally for any alleged transgression. So one looked at it, and I got to learn that there'd also been discussions about how that can be improved. So I looked at the Act, and I realized that there's actually a provision in the Act for kind of like an inspectorate, a body that would investigate the conduct of prosecutors. I think it's, I think I provided these documents, if I can just remind myself quickly. It's a complaints mechanism that should be established. It's provided for in terms of, I think it's section 22.
Is it the Office of Ethics and Accountability?
That's what they call it now, but at the time, we were calling it a complaints mechanism. You know.
Okay.
We're still initial stages of creating it. I don't know how it currently functions, but the IMU, Minister, would investigate anything, like in any department with an internal investigative division. That's what it would do. So this one dealt with everything. But what Section 22 of the NPA Act envisages in mind, has in mind, is a different kind of body. if a prosecutor commits misconduct in the course of prosecution, who should investigate that prosecutor? At the time in the NPA, it was the IMU, the Integrity Management Unit. But if you look at the legislation, it suggests something different. So what you have is that you have officials in the IMU who may be labor specialists or specialists in something else, effectively investigating the conduct of a prosecutor. So basically they're investigating the conduct they don't understand. That for me was a problem. You can't investigate a function you don't understand because you're not qualified, you're not a prosecutor, but you're investigating whether or not a prosecutor acted properly or not. So the Motoso case, for example, would have been a case to be investigated by another prosecutor to assess on a peer-to-peer basis whether the matter was handled correctly or not. If it is not investigated by that kind of person, you're not going to get an accurate account of whether something wrong happened, because all you're going to get is somebody who doesn't have the same appreciation of the issues, doesn't understand how a prosecutor thinks. So if you're to be asked the question, what made you not call this witness? A labor relations practitioner would hardly have a clue how a prosecutor would have exercised a discretion to not call a witness or rely on this evidence or that evidence. Only a fellow prosecutor or lawyer at least would be in a position to ask the right kind of questions. So this is what I was then pushing for, to say, no, we need a complaints mechanism. And the document I provided were the initial stages of a consultant report towards what that complaints mechanism body would look like. So by the time I left, we hadn't quite yet finished with it. But we had engaged on some drafts, and I'd already indicated to the minister at the time that something of that nature was coming up. So that's that. And then as you work, you go and you meet units, specialized units were there. One of the things that also was brought to me, to my attention, obviously I knew about it, was the work of, continued work of the specialized unit. So one of the things I asked was, let's start with the SCCU. Who's in the SCCU here at HQ? And I was told there was a special director. I'm not, if you don't mind, Minister, I'm not going to name his name. He left the NPA. He's there. If I recall correctly, there was Advocate Blatenbach, Glenis, and there was somebody else. So it was like 3 people or 4 people or so. So like, okay, what do they do here? And like, no, they handle SCCU cases. It's like, okay, what are they doing that for here? Because the SCCU, as I know it, is in the areas of jurisdiction of the DPPs. In Pretoria, Advocate Mzinyati had his SCCU unit. There's an advocate there who's in charge of it in Joburg. There's another deputy director in charge of the SCCU in Joburg. So what is this SCCU doing here? What kind of cases are they involved with? Well, they call it cases, they have a look at them, and decisions to prosecute are made here, but they work very closely with these officers. So for me, I became uncomfortable with that approach, because like, okay, if you're here and you take decisions to prosecute here, what happens to the DPP? Does the DPP know about it? So yes, we engage, we know, we discuss. Long and short of it, I'm uncomfortable with it, I don't like it. If there's going to be dockets taken from heads of SCCUs for whatever reason, whether for thorough check or whatever the case may be, and they come to headquarters, which is basically my office, the NDPP office, and out of that check, a decision to prosecute gets made there, then I'm not going to have it, because what it means is that my office and me basically is making a decision to prosecute. And the problem I would have with that is that you're excluding the DPPs from that decision, even if you talk to them. They are the ones who should run these particular matters, make decisions. My powers will largely be review powers in terms of 179. So I'm feeling uncomfortable. It said, no, this is how it's always been done. It's not it's not an issue really. The DPPs really know. I said, I don't have a problem with it. I get it. I just don't like it, and I don't want it. So my suggestion is that these matters that are here, There are not so many as well. I said, please take them back to the relevant jurisdictions. But if you want to work on them, you could stay. But if you want to work on them, then I suggest you go and work on them in the relevant jurisdiction. So you can go to Pretoria under Mr. Mzinyati, or you can go to Gauteng under Advocate Kanyile, acting DPP. So
Maybe just to ask there as well, was there a review that you had done to evaluate the work of this team to see if, based on head office, they are there doing the work they've done, obviously, before you arrived, some work where you presented with like a review to say this is what, so that when you almost implement restructuring, which you're saying that they must go to the provinces, therefore you would have seen that it has value. What was the basis of that conclusion?
the basis was purely legal. It was purely legal to say, in the past there may have been decisions taken, but in my time, I would not want to be the one taking a decision. So if my predecessors were comfortable with it, that's also okay. I don't have a problem with it. But I have a difficulty with it because I see a legal problem, at least coming up in the sense that firstly, one, I would be undermining, or I'd be appearing to be undermining the DPP's consent. And most of the cases were largely Joburg and Pretoria. There may have been one or two from other jurisdictions. So I don't want that. Let them handle the cases and deal with them themselves.
But when you say legal advocate, Simelan, are you saying, because legally you are giving an impression that your predecessors would have taken illegal decisions by having those. There was nothing in the act or in law that did not allow for that. You just felt uncomfortable to have it. Am I correct?
Well,
but in law, legally, there was nothing precluding the national office to have such an arrangement, to have that team operating.
I wouldn't say in law there would necessarily be nothing preventing them, because I know that the national director can institute prosecutions. But what they informed me about was that these were cases that basically collected as part of monitoring the SCCU units. They would monitor the statistics, all of that stuff, and then when they see in the statistics and in the reports a matter that they felt it's necessary to have a further look at, they then ask for the information and the docket and they have a look at it. So my argument is that, well, when you do that, you can't either take decisions here of a prosecutorial nature, let those matters go back to the offices that were responsible for them. And I did have discussions, informal discussions in the offices, and everybody understood that to be, that's just how things are. There's no issue. Then when I said, well, I wouldn't like this, Ms. Kanyile, Mr. Mzinyati, I'm going to have these matters sent back with the people that want to handle them, if these guys were handling them. If they don't want to handle them, you'll then reassign them, and I'll see what I do with them at HQ. That's effectively. So
you disestablished it at that time? Because we do have Kanyile heading the SS.
No. Kanyile was the acting DPP in South Gauteng.
No, I'm saying now, it's Kanyan, it's SDPP. Special Director, Public Prosecution.
Ms. Kanyane was there, she remained in my office.
No, I'm saying you disestablished, I'm just saying currently, this unit is back into national.
Yes,
it's also existing.
After I left, they reversed my decision. My decision was reversed.
That's the context I was saying to you. There's nothing illegal about it being in national. Because before you, it was there. You felt uncomfortable and said it must go to the provinces.
Yes.
After you left, it was brought back.
Yeah. There's nothing illegal in that. You can have it there to analyze statistics, because you get all manner of information. There's analysis, there's strategy information, you analyze, and if you're specializing in analyzing SCCU information, that was never a problem. I said, I don't have a problem with it. Where the problem comes in is when you're then going to have a docket that you're going to be looking at and investigating and deciding on the docket here. But if you're analyzing information, it's no different to analyzing normal prosecutorial statistics for purposes of informing strategy, planning, measuring performance, as the case may be. So that wasn't a problem. All that moved were the actual dockets that were there at the time. Yeah. So I did the same thing with soccer to say, to the extent that there's a sexual offences unit where prosecutors were there for purposes of taking decisions on prosecutions that were in the Tutuzela care centers. I said, you shouldn't be here at HQ. You should work in a Tutuzela care center and take decisions there. Here, you can sit and analyze information and do all of those kind of things. So what I then did was I put together a memorandum, submitted it to the minister with a recommendation that this be done because only those kind of things can be approved by the minister, at least as a final decision. I submitted that and there was an approval and it was implemented. Yes, there were people who were unhappy with it. There were, in fact, the special director at the time said to me, well, I'm here, what am I going to do? I analyze, if you're saying I must go to the DPP office and run a prosecution, I haven't done that in a couple of years. I'm happy doing analysis. My argument was, I don't have a problem. You can be around as long as you don't take decisions to prosecute. Also, don't have a problem. You can pick and choose where you want to go and work. I really don't mind. That is not the issue for me. The issue is I want to be protected so that as the NDPP, when I have to make decisions to review when representations are made, I don't want to be put in a situation where I can't do that because an earlier decision had been taken in my office or had been taken with my knowledge. Because if I did that, the way I saw it, if I was part of taking that prosecutorial decision or it was taken under my authority in my office, and then a party put representations to the DPP and escalated them to the NDPP, I'll then be functus officio because I would have been part of the initial decision making. So my view was that let me protect myself from this and take a step back and allow the DPPs to work. And part of the reason was that when I engaged with DPPs, as we did in EXCO, I learned that they had been uncomfortable with not being part of EXCO, that they were uncomfortable. They were more comfortable that they were part of the executive committee and reporting directly to the NDPP themselves. They were always uncomfortable reporting to somebody else who would speak on their behalf to the NDPP. They felt that they could do that better themselves as the primary people responsible. So it resolved itself in that sense, but I was able to manage the relations between the officials. Fortunately, they were all really good people. There was no issue at all. The matter resolved itself in that way. So that's what I did at that particular time. Then there were a couple of cases that we handled. Handled in the sense that the nature of my relationship with the DPPs, Minister, was that you do as you please. It's your job, it's your power. All I do is hold you accountable. There's a performance agreement. If there's a complaint about you, that's where I come in. But you take all the decisions. There are certain matters that are referred to as high profile for whatever reason. I never understood why. It didn't really matter to me. But you make those decisions. But if you want my support, it's in your interest to keep me informed and briefed so that I know what you're talking about. And if the NDPP were asked, I need to be able to also respond and give the most accurate information. You exercise, I either refer the people to yourselves to talk to the issues, or if you want my support with whatever decision you make, it's better we have a relationship where we brief each other more often. More often as in more than the scheduled briefings of EXCO meetings once a month. So some DPPs took that up, others really didn't. It didn't matter, it didn't affect our working relationship. As part of that work, let me just find these cases that I mentioned so that I deal with them. What I used to do, the question then was, okay, what does an NDPP do if you're sitting in your office and the DPPs are doing all this work by themselves? So I had to think about what the best way would be for me to not only keep myself busy, but try and identify things that would be critical to attend to. Now I'm just trying to get my files, if I can have your indulgence quickly. So what I would do in the mornings, I would read the newspaper. I read the newspaper, and then I finish reading the newspaper, pick up something that that comes up that would be of interest, and follow up with the DPP, office.
Okay.
One of the matters that was in the front page of the Sowetan one day was a matter of, over the weekend, some young people had allegedly been drunk and allegedly had taken some drugs, and they decided to race cars in Soweto. And during that process, they, because of their condition, they ran over some pedestrians. I think one or two, if not at least one, pedestrian died as a result. Another was paralyzed. So I took that and I immediately called...
Is it the Jub case?
Yes, the Jub case. I immediately called the acting DPP in Joburg. I said, have you seen this newspaper? She had it and said, okay, let me just get it quickly. And she got it, says, yeah, I see it. I said, you know, this is a problem. This is interesting in the sense that the way this thing happened, how can you drag race in Soweto? I can't imagine what street it would have been in Soweto. I'm not a Sowetan person, but I've been in Soweto. So I was trying to imagine where they could have done this. So I requested, I said, no, Oli, can you send a prosecutor there, find out which courts these guys would be appearing in? And let's find out what happened and let's talk about this, because for me, this is murder. We should have this as murder. She said, murder, really? Okay, no, it's fine. Let me go have a look and then we'll discuss. So...
You were having a discussion with who on this matter?
The acting DPP in
Okay.
So she went to speak to prosecutors following their process, and then we started having a discussion about it. And the question was, no, but you know, it's not going to be murder because generally in drunken driving, we charge with culpable homicide. I said, you know, I'm not so sure. You know, we had a long debate about culpable homicide. I said, no, I'm not so sure. I'm not convinced. If what is reported is correct, that the individuals drag raced, it means they must have had a conversation about racing. And if they had a conversation about racing, it means the race was intended. It was intentional. It was an intentional decision to race from one area of Soweto to another area of Soweto. So for me, that is intention. Why would you say it's just cup? So I said, well, you know, it's never happened this way. It's difficult. So I said, you know what? Perfect to do a test case. Let's do a test case with this. Let's charge them with murder as a first charge, so that if we fail on murder, we get a competent verdict of culpable homicide instead. Because if you charge with murder first, or culpable homicide first, and you don't succeed for whatever reason, you have problems. So we discussed, and we're like, okay, you know, let's do a test case, because all the elements were there. It's the kind of case in law, if you want to test the law and have a test case, the general rule is that you must find the best facts for that to do. You don't use difficult facts because it doesn't work very well. Find the perfect set of facts, and then you can go and test your theory in courts.
At this point, Advocate Simelane, you are having this discussion on the basis of a Sowetan report.
No.
Not what
this was now a couple of days later, because there had been further engagement between the prosecutor dealing with the case with the police and all of that stuff, getting information, statements from people. But
yeah,
the
because you didn't mention that. That's why I'm worried.
Okay. No, understand.
Because you're saying you saw a headline on Sunday. You called the acting DPP to say this thing, these people, if they drag race, as the report of the Sowetan says, therefore it means it could be. And that's why I'm worried about that basis.
Oh, yes. No, understand. No, this was a couple of days later, as I was getting more information about what happened, number of people involved, who the individuals were, where they were coming from, what is suspected is the drugs that they're taking at the time. But the principle about how we would consider approaching the case, yes, I'd looked at this Sowetan to say, based on what is reported here, I think we can start looking at this principle. But when all of that was done and the information was ready and docket was ready, we then tested to say, please have a look at this and have a look at it and let me know if it is indeed the kind of case where we could have this test case. So they looked and said, no, actually we can. There was additional information subsequent to that obtained eyewitness accounts. Some of the people and the friends who were there, their account of information strongly suggested that there was an element of boasting between the parties about who drives better, who can race better, and all of that stuff. So it fitted the elements. So the conclusion was, okay, we'll try it and use a test case for this purpose. And it went, and fortunately, the conviction went very well, and the rest is history vis-a-vis those
I
individuals.
want to move on from this segment. You still have something that you want to say?
Okay, let me be quick. I then dealt with because there's 1, 2, 3, 4, 5, 6 cases that I specifically was involved in that may be worthy of mention. Then the second case was what was referred to, I can't remember the name of this case, but State versus somebody else, but it was referred to in the media as the Naomi Campbell Diamond case. If you remember that. The issue about it was that somebody had been given by the supermodel Naomi Campbell a diamond, and it was alleged that Naomi Campbell or somebody had obtained this diamond from Charles Taylor in Liberia and so forth. It became a public ugly thing. Now, the interesting in this case is that, well, it was in court. Then it was going to run, and I received representations. I received a call from the late advocate George Bezos. He said, Menzi, we knew each other. He knew me. He knew my dad, and he knew me. He said, Menzi, I need to see you about this case. I act for this individual. And I said, no problem, Mr. Bezos. Whenever you're ready. He said, now come to you. He came.
So he made direct representation to you without the DPP?
Yes, he came direct, yes, without the DPP.
Shouldn't they have gone to the DPP?
Yes, well, they would have. I think they did, in fact, go to the DPP, but he first wanted to speak to me about the case to let me know that he's involved in this case. I said,
so before meeting the advocate Bezos, did you ask for a report or meet with the DPP to understand? Because my understanding of the process is that representation will be done with the DPP. You will be the reviewing process, isn't it? If the decision by the DPP is asked for you. So in this case, you are saying to us, Advocate Bezos comes to you directly, having not gone to the DPP.
Correct.
To afford the DPP a decision-making process which is allowed by law.
Yes. He was not asking to make representations. He was asking to see me about the case. So almost like a meeting, but not really a representation. So I said, no problem, we can come through. Then I arranged for one of the...
In the middle of a case, which you could have powers to review, Advocate Smelan.
No. For now, I was just asking for a meeting. So the question was, okay, I hear you're representing this individual. We can meet. So for me, I was curious to say, okay, what does he want to say? Let me hear him out.
You were aware that he's representing an individual
he said so.
On a case that is before court.
Yes.
And your DPP has not come to you to say we want to engage. What was the basis of you agreeing to that meeting?
No, yes, I did inform the DPP that there's going to be a discussion. I'm going to meet Mr. Bezos. For now, it's just to hear what he has to say, because I don't know what he's going to say. The matter wasn't running in court yet. It hadn't started running in court. I think there was an appearance already, and I think the gentleman was given bail or something like that.
The case was before a DPP who
correct.
had made a decision to prosecute.
Yes.
But don't you think that is irregular?
No, it's not irregular, Minister. What I then did was, I then asked the prosecutor...
You know why? Let me finish.
Okay.
You just said to us, you decided to remove the soccer. You decided to, because you felt that you didn't want to undermine your DPPs.
Yes.
You wanted to ensure that the powers of prosecutorial decisions are with the DPPs, not with the NDPP. So if the dockets are sitting with you at national, it would have meant that you are undermining your DPPs. Therefore, you wanted the dockets to go to the provinces, to the DPPs, for them to make a decision. Now, in this case, the docket is with the DPP. A representative of an accused is requesting to come and see you while the case is being dealt with by your DPP. Isn't that not an undermining of your DPP, which you intentionally, when you arrived, felt that you needed to give them powers? Was it not counterproductive for what you were doing and what you saw as a vision of your tenure?
Not at all. This was purely going to be a meeting to say, okay, you're going to meet. What do you want to discuss? What are the issues? What I then asked for from the DPP was the prosecutor who was dealing with the matter to say, because there's somebody who's dealing with the matter, can somebody be here so that also I'm not alone? So I want somebody to be here with me so that we have this particular meeting, which did happen. So there was a prosecutor there who came, and Mr. Bizo said, you know, are you going to proceed with the prosecution because we are going to be making representations about it? So I said, no, it's fine, you can make representations. What is the issue of concern? Then what he indicated was, well, you know, for us, we would argue that this matter should not be prosecuted. Then we debate, why should it not be prosecuted? He made arguments to suggest that it's de minimis, you know, we're going to be making.
At the stage, you are now engaging
Yeah,
representation.
he's starting to, yes, you know, he did. He's starting to say, well, this is, we think it's de minimis. So I said, well, I don't think it's de minimis, and I don't agree with that. My suggestion is that we're going to proceed, you guys will do whatever you want to do and make the representations. Then
Okay.
he left on that basis.
I've got colleagues who wants to follow up. Prof, and then the two colleagues.
Thank you, Chairperson. Advocate Melane, you invoked something when you were making changes to your office that you wanted a federal type of arrangement,
Yes.
which expressly would mean you give your deputies direct power. So by accepting this invitation to meet from, you know, Judge Bezos, was it out of respect or was it out of what? Because surely when you already know that the case is being handled and he'll be representing the other side, you would have known through your judgment that there's no way the person is going to just come, sit, and you chat around this particular case. Because this seemed to be counterintuitive to the very logic you introduced when you were making changes.
No, I don't share that opinion. I don't share that view. As NDPP, I met a lot of people who would ask for meetings about many things. Others would want to just share their views. My condition was, of course, not a problem if you want to meet. Obviously, one would create the appropriate framework for it. In this case, I'd made the DPP know that there was going to be this decision, and the prosecutor involved, can he be there so that we can listen to what is being said, and then we'll find out what is being said and then take it from there. So indeed, it was partly out of respect, but he's not the only one with whom I've met with prosecutors. But it was really to hear what the issue would be. So beforehand, I didn't know, but when he came, he said, well, this is what they would argue in their representations. Then I said, no, it's fine, then I'll deal with those when they come, but I'm not inclined to not want to have the matter go ahead. And then the meeting ended on that basis.
Thanks, Minister. Good afternoon, Advocate Miller. With all things considered, me and you would know as part of the other lawyers in the room that there's a good reason why we create a rule. And the reason we create a rule, we would expect it also to be followed, probably hierarchically by everyone. Your expectation when you were at NPA would have been that a public prosecutor at a district court would not willy-nilly accept representations. without the participation of the SPP or at least your DPPs in the provinces until either the decision is then reviewed by yourself. And that's a rule you made. Wouldn't you have been comfortable that nobody would have gone against that rule?
Would I not have been comfortable if?
Would you have been comfortable, rather put differently, if anybody went against that rule? Say, for instance, somebody started with the DPP and went back to the prosecutor down there without that prosecutor and the SPP having had an opportunity to make the decision on the prosecutorial nature of the matter that is before them.
No, in the sense that on the ground, people would speak to anybody. Representations are made formally,
Yes,
generally, right?
true.
So when they're made formally, they follow the process.
Yes.
But outside of formal representations, people want to meet to explore attitudes. Sometimes they would say, look, we just want to explore an attitude. We want to consider raising this issue or that issue or that issue. This was that kind of meeting to gauge what your attitude would be to issues that we would want to raise. So come and raise those issues. But it's not the formal representations, because remember, the formal representations, more often than not, they are written. So this was not a case where there were written representations that needed to come.
No, it's fine, Advocate Miller. I'm making a simple point of a simple principle of a rule. And I want you to take us into your confidence that in receiving this meeting request from Advocate Bezos, SC, as he then was, in his lifetime, you were not creating an opportunity to be clouded. Because at the time that Bezos calls you, it's not that the case is not yet in court. There has already been an appearance. He tells you even over the phone, I want to see you, I'm representing this person. From that moment, doesn't it occur to you that then Bezos is using proximity to you in order to get this possible added advantage? Does it not occur to you at the time? And I'm just looking at it, colleague, from a point of hindsight. No. I mean, you took the decision at the time. You can't undo it now. So reasoning it may not need to be on the basis of, do I think I was wrong? And that's how I'm looking at it.
No. On the principle of the rule, you are correct. But no, I didn't see it that way.
No, that's fine.
I spoke to the DPP.
No, that's fine. Thanks.
Mr. Mutlu?
Thank you, Minister. Advocate Simelane, the challenge I have as well is that what you were avoiding in terms of you having to disestablish that arrangement, the arrangement that you found to be uncomfortable. The basis of that, according to you, was to avoid being functus officio. Now you get a call from Advocate Bezos, and on the basis of that call, an arrangement is made and a conversation takes place, and you actually expressed a view in that meeting, where your view is that there is a case to prosecute, and you are not going to accept the representations, irrespective of whether they are formal or informal. But you took a decision then. So in that way, if Advocate Bezos was to proceed with a formal representation to the DPP, you would, and the DPP takes a decision that, or a view that they are proceeding to an extent that you would have to escalate that decision or challenge it to your office. You would have technically excluded yourself from the process and created a situation, an environment that would be unfair to the person who was making representations. Thus, you would become functus officio, a situation that initially you would have avoided. You agree with me?
No, I don't agree with you because I don't share the way you're characterizing that meeting. As I indicated, all that was indicated at the time is that I just want to discuss this particular issue with you to raise certain propositions about how we intend to approach the particular matter, right? We want to see if we can see you for that purpose. So I said, yes, you can come. I could have said, no, put everything in writing. So I said, no, it's fine, come here, if you want to come here. So that's how that meeting was. It wasn't a meeting in which that kind of discussion would take place. So it wouldn't follow the logic that you are submitting.
But then you make a request through the office of the DPP that the prosecutor handling the matter must come along to discuss the merits of the case.
No, not the prosecutor handling the matter in courts. It was a gentleman, I don't want to mention his name here.
But to discuss the merits of the case.
Not the merits of the case, to be there with me so that I have somebody else with me, at least who's familiar with the case.
Yes, to discuss familiarity with the case, to delve into the merits of the case.
It was not to discuss the case. It was to hear. Remember, they had not indicated what proposition they would want to take forward or what they would want to argue. So I said, okay, I'll hear you. It was only when he had arrived that he said, we want to make representations, and we would want to make representations in terms of which we're going to argue that this is de minimis.
Yes.
Yeah.
And you took a stand there, a position then, that that issue was not de minimis, that in actual fact you would, the prosecution will proceed.
No, I said I would not deal with that matter on the basis that it would be de minimis. The matter will go to court and be dealt with there, because that's where it already is.
So had this matter now been formally, or those representations, if they were formally presented again to you, would you have considered them, or would you have been, or become, or rendered yourself functus officio?
No, because there would be no decision. To make a decision as the NDPP, I would have to formalize it. So what would have happened if, to follow your logic, I would have had to say, let's say he's there, say, let me hear you. Goes into the full details or the merits and all of that stuff. I would also then need to know what is in the detail of that particular docket. At that time, I didn't know. I would need to be on all fours on that particular docket and then formalize a decision in the way of writing. So all of that was not even in question, because at the time, I didn't know the details of the...
So just to avoid dialogue, so you considered that decision to be an informal decision that you communicate or conveyed to Advocate Bezos?
No, it's not even a decision. I mean, it's simply saying...
It's an expression of a view.
Yeah, that I guess I would need to be involved in the matter at that stage, yeah. You can call it that, yeah.
While other colleagues are coming in, Advocate Simela and I have a difficulty here.
With time. Oh.
You call a person who's involved in a case. If it was just listening, why didn't you take somebody from your office, in head office, to sit with you to listen? Why particularly you had to call somebody who was familiar with the case, coming through from being there to sit in the meeting, if the intention was not to deal with the case itself?
No, the gentleman is in the NDPP's office, but I'd asked him to go and speak to the prosecutor at the court about the particular matter to find out.
No, but you are changing your versions.
No.
And there are two things that you have changed. One, you've said that you've asked the person responsible, you spoke to the DPP, because I asked. You said you spoke to the DPP, you asked for the person who was familiar with the case to come through. Now, if you are saying it's somebody from your office, so does the people in your office familiarize themselves with all the cases? At what point was this person in your office familiar with the case? Did they go to the, so I'm confused there. No. The second area of confusion I have on the statements that as we ask the question, it seems to be changing, is the issue around what was, because you initially said, I told Judge Bezos, we're not gonna take representation. And you're saying it's not a decision. But for me, sitting here listening, it's a decision. You are the highest authority in the NPA that makes decision. no one else is going below you would be able to take a decision that contradicts the NDPP. We know the authority of NDPP in the NPA. Now, if you say, I don't think DPP, West, who's acting, would have gone and listened to a representation. For me, that's where the issue is. Understanding your level of authority in calling the people, calling this person. So if this person was not involved in the case, and it's person in your office, how did that person become familiar with the case?
No, familiar in the sense, Minister, that, you know, you could say to an official, please go to that court. I'm trying to understand where this matter is at, what is going on, what are the issues about. Official goes to that particular court, speaks to the official handling that particular matter, and comes back and gives one feedback. It is different from the engagement where you need the information for purposes of making a formal decision, because that comes through the formal route via the DPP. So this was really to get a hang of what that matter that is reported in the media about.
But if the intention was never to discuss the case, why would you go to an extent for a person in your office to go and familiarize themselves with the case?
Just so that
Because
I know,
the issue is, you are saying to us as a panel, you had no intention to discuss the merit of the case because you had no docket, and you had not been briefed by the person that was supposed to be briefing you, who's supposed to deal with the case. Now, why would you not then get the information and get the DPP to brief you, rather than send a person from your office to go and get the case?
no, not to go and get the case, Minister. There's nobody who was going to go get the case, because that suggests something different. All that this individual was going to do was to go and find out the elementary facts about the case, so that when the meeting takes place, one is familiar. And then I hear what the advocate was going to be saying, and then have a discussion from that perspective. So it is different from a formal engagement. It's not mechanical in that way. So I'd let the DPP know that there was going to be that meeting about that case.
I've got Mfundisi, maybe just to ask, was this the modus operandi, where you'd have informal engagements? If somebody calls you and say, I want to see you, there's a case, you'd agree, have this. Was this an isolated incident or just the normality?
No,